Okay, let's get into Chapter 6 and talk about witnesses. All evidence is introduced at a trial by testimony of a witness. We know that. We talked about that before. There are 5 key issues that relate to a trial witness. Number 1, who is competent to testify? 2, how the credibility of a witness is attacked. What can be done if the witness's memory is faulty? What a layperson is allowed to testify about. Now, that's just a regular person who doesn't have any particular special knowledge, not an expert. And number 5, how and when an expert witness can be used. So let's talk about a competent witness. The definition is a person who understands the duty to tell the truth, and that person can narrate the events in question. That's it. First of all, an oath is given. You've probably seen this before. Do you promise that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. You've seen that before, right? So once they take that oath, they are testifying under penalty of perjury. If they knowingly lie, they can be charged with a crime. Child witnesses, it must be established that they know that they're required to tell the truth, the right and wrong of it. And hypnosis cannot be used in court to refresh someone's memory. A competent witness has the ability to narrate the event in question. Remember, the evidence is being delivered through these witnesses. So they must be able to communicate effectively. They must be able to understand the questions that are being asked. Sign language can be used if necessary. If there's any question of the competency of a witness, a hearing will be held and questions will be asked to determine whether the witness is competent. The burden of proof of competency falls on the attorney who calls that witness. Now, let's talk about impeachment. I'm not talking about the kind of impeachment that relates to presidents. Impeachment of a witness, it's a key function of cross-examination. It's to convince the jury that a witness should not be believed, to reduce the believability of the other side's witness. In some cases, other witnesses are called for the purpose of impeaching the witness that's already testified. The process by which a witness is impeached is through the asking of questions. Those questions bring things to light that the jury can interpret and decide whether or not to believe more or less the testimony of that witness. And of course, in closing arguments, those questions will be brought out again by the attorneys. 6 methods of impeachment. Number 1, showing that the witness has some bias or prejudice. Number 2, the witness has prior felony convictions. They can still testify, but the jury can consider this when evaluating how much weight to put on the witness's testimony. Immoral acts, or say undiscovered, uncharged crimes that they've committed in the past. Prior inconsistent statements. Oftentimes, the police will have interviewed somebody on tape. If that interview is inconsistent with the testimony they're providing in court, you told the police when you were interviewed that you weren't even there, and now you're saying you saw the whole thing. That's an inconsistency that would be brought forward. The inability of the witness to have even been able to see what it is that they're testifying about. And finally, the witness's reputation. The witness's reputation can be attacked through impeachment. If a witness has been impeached, in other words, their credibility has been attacked or their believability, the attorney originally calling that witness will need to rehabilitate them. That means to restore their credibility and believability before the jury. Again, this is the attorney's attempt to convince the jury that their witness is actually credible after they've been impeached by the other side. When impeachment is focused on the witness's prior criminal conduct, the rehabilitation part of it usually includes trying to point out all the witness's good deeds and how long it's been since their last crime. That's about all you got. Corroboration. Evidence or testimony that tends to support what a witness testified to. An example would be a witness says they saw the suspect throw the gun into a garbage can. Police reports and photographs of the officers recovering a gun from that garbage can would tend to corroborate what the witness testified to. There are situations in which corroboration is mandatory. When you have a couple of suspects who commit a crime together and one is brought in to testify against the other accomplice, then that testimony alone is not enough. It requires there be some corroborating evidence. Obviously, the suspect testifying against his accomplice has an advantage in blaming the whole thing on his buddy. Need corroborating evidence. Memory failure. When a witness's memory has failed, an attempt can be made to refresh their memory. In preparation for trial, the attorneys go over all the testimony that the witness will be expected to talk about. They'll go over all their questions and anticipated questions from the other side. The bottom line is that witnesses must be able to testify by memory, their memory of the incident, not memorization of something that they were coached on or reading reports and statements. They have to be able to present what they recall from the time. There are exceptions to this. There's a concept called past recollection recorded. Now, this has happened to me. As a police officer, I'm testifying on the stand. A question might be asked about, well, what day of the week was it? What time was it specifically that you were dispatched to the call? I can't remember that far back. I've handled a whole bunch of cases like this. The district attorney would ask me if reading my report would refresh my memory. I am then given a moment on the stand, still sitting there. The whole courtroom is looking at me. I unroll my police report or unfold it in front of me, and I read a couple of paragraphs and try to refresh my memory. I do not read from the report. That's not allowed. But I can read from the past record. Once I've taken a look at my report, the district attorney will say, "You've reviewed your report. Did that refresh your memory?" My answer, yes or no. If it's yes, okay, then go ahead and answer the question. And then I'll answer the question based on my refreshed recollection. Whenever I received a subpoena, I always made it a habit to go to records and get a copy of my report, take it with me, have it in my hand when I go up to the stand to testify, because more often than not, this kind of thing will happen. Before I read that report to refresh my memory, the DA has to establish one other thing. Normally, it's in the form of a question. Officer Ruden, when you wrote that report, was the incident at that time fresh in your mind? The DA is establishing that I wrote the report right after the incident occurred. It was freshest in my mind at that time, and now I'm using my own recollection from then to refresh my memory now and then to testify. Again, I do not read from the report, just use it real quick to refresh my memory. A couple other things, unavailable witnesses. Sometimes a witness is unavailable. The court might allow a recorded version of the witness's testimony if it's properly prepared. These are statements that are made under oath, maybe at a prior court hearing. The record is then read during the trial. Some states allow sworn statements and video, taped or recorded statements for use later at trial. A good example of that is with child crimes. Children are interviewed one time when they are a victim. That way they don't have to be interviewed over and over again and then go into court in front of all those people and then be dragged through victimization again. Most places use what's called a multidisciplinary interview center, where all the interested parties are behind a two-way mirror, and a trained professional interviewer asks questions of the child, goes through the statement and testimony. It's done once, it's recorded, it's used in court later. Sometimes you have material witnesses that are in jail, so we have to use a recorded statement. Okay, the opinion rule. First of all, lay witnesses. That's just folks who are brought in to testify who don't have any particular scientific knowledge about the case. Opinions of a witness are not admissible because it's the function of the jury or the judge to analyze the evidence. Witnesses can only testify about what they saw, what they observed that's relevant to the case. They answer questions from the attorneys and talk about things that they experienced themselves within their five senses at the time it occurred. They're not permitted to state conclusions or give opinions. Again, that's the purview of the jury. They are the trier of fact. According to Federal Rule of Evidence number 701, it lays out a little bit of an exception to that. I'll read. If the witness is not testifying as an expert, the witness's testimony in the form of opinions or inferences is limited to opinions or inferences which are rationally based on the perception of the witness and helpful to a clear understanding of the witness's testimony or the determination of the facts in issue, and not based on scientific, technical, or other specialized knowledge. That's a lot of words. But what it basically says is there are some times when a lay witness can give their opinion, but not in the case of scientific, technical, or specialized knowledge. That is reserved for the experts. Let me give you some examples of what I'm talking about. Admissible opinions by lay witnesses include somebody's handwriting. Let's say somebody's testifying that it is her husband's handwriting. She's been married to him for 40 years. She knows what his handwriting looks like. Statements about someone's emotional state. Most people can understand when somebody's upset, angry, enraged, frightened, so those types of opinions are allowed. Someone's physical condition. They were laid out on the ground, unconscious. Individual seemed out of it. Voice identification. I recognized his voice. I work with him. He's called before. Whatever the case may be, voice identification is allowed. General statements about someone's mental condition. The person wasn't acting normal, or they were acting normal. Nothing seemed unusual. A photo lineup. It's the same thing as a police lineup where you get 5 or 6 or 7 suspects up there lined up shoulder to shoulder, and the witness says, it was number 3 who did it. The real way that's done nowadays is with photographs. A lay witness can have an opinion as to whether or not a photograph is the person that they're identifying. And general statements about vehicle speed. This is one that just happens to be in there, but you're not an expert. You're not measuring a vehicle's speed, but most people can say if a car is going really fast or a car is going really slow. That is allowable. Let's talk about expert witnesses. Different story. Expert witnesses are called to help the jury understand evidence, and they're only allowed if the facts cannot be understood by normal run-of-the-mill jurors without the help of an expert. There's a wide variety of specialties in which experts can be useful at trial. There are tons of them. A lot of it has to do with forensics. Sometimes it has to do with vehicle issues. Some expert testimony requires that the expert have extensive education, specialized training, extensive experience before they are certified as an expert. And expert testimony cannot invade the issues that are normally the purview of the judge or the jury. The judge is the trier of the law, so experts cannot give interpretation of the law. That's completely up to the judge. Experts cannot give certain opinions or come to conclusions that would be the purview of the jury. Here's an example. An expert witness might be a psychiatrist, and they might state that they diagnosed the defendant as having schizophrenia or being clinically depressed, bipolar, but they cannot testify that the defendant is criminally insane. That's up to the jury to make that decision based on what the experts and all the evidence shows them. If you take a look at your textbook on page 167, table 6.3 and 6.4, there's some examples of allowable opinions by lay and expert witnesses. You can take a look at that. Okay, the Frye standard. This comes up a lot. Frye versus the United States back in 1923 held that a scientific technique is admissible in court, but only if it's a generally accepted science that's considered reliable in the relevant scientific community. So what does that mean? The Frye standard says that things have to be accepted by scientists before it can be brought into court as valid. You can't bring in voodoo. You can't go into court with an expert witness who testifies that ghosts give off a certain radio frequency and therefore whatever. Those kinds of things are not established as valid by the scientific community. Things that are recognized by the American Academy of Forensic Medicine, the American Medical Association, which means that some techniques are not acceptable because they've not been proven to be sufficiently accurate. Polygraph tests. We use those in the hiring process for peace officers in California, but they're not allowed as evidence in court. They can't be testified to as being conclusive truth verification. Psychics, astrologers, stuff like that. You get the idea. Attorney has to lay a foundation for the expert witness. In order to use them, they must establish a few things. They are: the jury needs the help of some kind of an expert. There's a recognized area of expertise that applies, and the person who's called to testify has the right background to qualify as an expert. They can't just be Anybody. More about the expert witness. If I were to call an expert witness onto the stand, the opposing attorney might voir dire my witness to establish that they are satisfied that that person is in fact an expert. Remember the video clip from the movie My Cousin Vinny. The opposing attorney might strategically avoid a lengthy voir dire for this reason. Many experts come in with impressive resumes. They're up there on the stand, and if I'm the opposing attorney and I ask this expert to lay out all their training, certifications, licenses, their education and experience, it might be so impressive to the jury that they're going to believe everything that expert says. So I might avoid it, or when it starts going down that road, the opposing attorney might say, Your Honor, I stipulate this is an expert. I have no problem. So I've seen it where opposing counsel will want to shut that off, or even ask that it be done outside of the jury's presence so it doesn't unfairly prejudice the jury toward believability of that witness. And of course, here's an example of this scene in My Cousin Vinny, where in that case it was the prosecutor was trying to show that Ms. Vito, I think was her name, was not qualified as an expert in automotive science and could not testify. And of course, he was proven wrong. Obviously, counsel will ask questions of the witness regarding their background. The jury then will decide how much weight to give the testimony. That's why I mentioned strategically the opposing attorney might not want all that pedigree coming out because they'll give more weight to the witness's testimony. The purpose of the expert witness being there, they will be asked about their inspection or testing of the evidence, and they can give their opinion based on their expert knowledge. They might even be asked hypothetical questions, and they might be able to draw conclusions based on the facts that are already admitted into evidence. It's because they're experts, they get special treatment in the courtroom. Take a look at some of the examples of what expert witness testimony might look like. It's on page 171 and 172 of your textbook, specifically some examples of expert witness testimony about sanity, ballistics, and DNA. Well, that concludes our review of Chapter 6, and I'll see you in the discussion boards.